Hello and welcome to the Lobster Pot podcast / day 2 of Product Earth's Seminar Zone. Boom. So today we have Stewart Eccles, who was due to speak, and he is a patent attorney. How are you doing, Stewart? Good to see you.
I'm very well, thank you. Good to see you.
Excellent. So tell us your topic and what you're going to be presenting on, and tell us a little bit more about yourself.
Well, will do. So the topic today is safeguarding creativity and advancements in cannabis, IP rights explained. So IP rights are intellectual property. And what I do on a day-to-day basis is help people protect their innovations. So whether those are inventions or whether those are aesthetic creations or anything really that involves some form of innovation or thought. And what I will do today is I will give a very brief overview of a lot of different aspects of intellectual property. And I have some of them, if I duck down a little bit, above me here, some examples. And a question that I wanted to ask the audience in the first instance was whether or not you believe you have any intellectual property in any of your business operations or any other operations that you do. And I would not be surprised if that answer changes at the end of this talk. So the first topic that I want to cover is patents, as that is closest to my heart, as I am a patent attorney. And I'm going to use one slightly exaggerated example of what most people might think is associated with patents. And so what I have here is an absurd inflatable mobile phone, a little bit dated, I would suggest.
The bigger the phone, the louder you have to shout, yeah?
Exactly. And everyone probably recognizes that there is a lot of high-tech invention that goes into a mobile telephone. And people probably associate mobile telephones and other areas of high tech as the sort of technology you can get patents in. But I spend quite a lot of time blowing inflatables up for my kids. And I don't know if any other parents out there have done the same, but when I'm blowing these up, I've lost it now, I always look at the valve on the inflatable and look at the myriad of different ways that people have come up with making it harder to blow these things up. Because if you look inside the valve, you will see various cuts, various pinch points, various ways in which the inventor of this valve have come up with making it harder for the air to come out, but easier for the air to go in, although it's still quite a test in my experience. So there's a lot of innovation that goes into something as simple as a valve on an inflatable. And my point here is that high tech, yes, very much going to be patents within the high tech space, but equally things that may appear to be relatively simple can also be subject to patent protection. And the reason for that is that in order to obtain a patent, you must have come up with some form of technical contribution. So what you're looking for when it comes to patentability is something that's new and something that's innovative. And that innovation can be relatively simple. Simple does not necessarily equate to obvious, which is one of the tests for obtaining a patent. So I've got another example behind me that you can't really see, and that is this. So this is a packet of pencils. Now these pencils are an item that I managed to get a patent for. Now you may think, how on earth have you managed to get a patent for a pencil? Pencils have been around for hundreds, if not thousands of years in some form or another. And in this case, the innovation came with this end of the pencil. And hopefully you can see this, but inside there, It's probably not focusing. Inside here, what we have is some compost and a seed. And the idea with this pencil is that you can use it up, you get it down to about here, and then you can plant it in soil like that. And then the seed will expand out of here, and it's actually got the flower name on here. So the idea behind the pencil being that you can actually have some lasting benefit from this pencil when you actually get it down towards the end. Personally, I don't think I've ever got a pencil down to low enough where it might actually be worthwhile planting. But in this case, again, we've got a relatively simple item, and the innovation in this case related to the form of the compost within it. It was that the compost could expand when it got damp. And the expansion of the compost when it got damp meant that the conditions for the seed to thrive were much better in order to allow the seed to actually germinate and grow, much stronger. And again, that relatively simple aspect of that invention is what we were able to rely upon to convince a patent office that it was inventive. So the message that I really want to get across here is that patents are easier to obtain than people might think, and the benefits of having a patent can be big. They are an asset that you can list on your company's balance sheet. They are not just something that you can try and enforce over someone. They can bring a lot of value to a company outside, above and beyond simply being able to stop someone from doing something with what you've invented. So again, behind my big old bushy head, we've got various other things, and hopefully people, if you are looking at what is behind me, you can recognize potentially some other forms of intellectual property. Now, I think one of the most obvious other forms of intellectual property from all of the various bits behind me is trademarks. So what we have behind me is some big name brands. We have Nike, we've got Cadbury's, we've got Coca-Cola. These are all household names. And the reason that they are household names is because companies have put a lot of time and effort into ensuring that people know who they are, and also ensuring that their trade names are kept as such. So a trademark, and as I use the term trademark and brands together because they do overlap to a sense. Trademark is the legal right. Brand is generally what we understand and what we recognize. But a trademark enables you to protect the name of a product or a service that you are providing. So in this case, take the Coca-Cola as an example. Coca-Cola is a product. It is a drink that is being provided. Cadbury's, food products, Nike, other product, footwear and clothing and whatnot. But equally, you can get trademarks for the services that you offer. So, I mean, the Empower Her mark there that I don't know whether or not it is on screen, Dave, but the Empower Her mark that is behind Dave is, and indeed the Thermador, that is a prime example of a name and a logo that could be subject to trademark protection. So, for example, the seahorse or the stylized lobster, as it looks to me, next to the Thermador mark.
Yeah, you're right.
You can get the protection for the name Thermador or Empower Her, and you can also get protection for those logos as well. And trademarks and brands, and it pains me a little bit to say this, being a patent attorney, but trademarks, brands are one of the easiest and most impactful forms of intellectual property. And we are all well aware of brands, household names, and the goodwill that is vested in all of those. And that is what trademarks are intended to do. They are intended to, so that a consumer can go to a product, they see Coca-Cola, they see Cadbury's, whatever, and they think, I know what that's going to be. I know that there's reproducibility there. I know that there's quality there, and I am happy in purchasing that again. And I don't know if anyone else experiences this when going to a restaurant or somewhere else, and you ask for a Coke. And Coke is a trade name. Cola is the generic name for the drink itself. And most of the time, to be fair, nearly every time I ask for a Coke and the location serves Pepsi, they will say, oh, I'm sorry, it's Pepsi, or maybe not apologize, but they will say it's Pepsi. Is that okay?
Yeah.
And the reason for that is because Coke is a protected name. And Coca-Cola, the Coca-Cola company, the parent company who owns the rights for Coke, does not want their trade name to be used generically to describe a cola drink. So they protect their brand by ensuring that any providers, any sellers, do not use Coke when referring to other cola drinks. So it's and a particular brand that failed on that point was Hoover. So Hoover is a brand name, yet whereas certainly I always refer to the vacuum cleaner as a Hoover.
Yeah, I think that's interesting. I definitely think that that's the sort of thing everywhere else will say a vacuum or whatever, but it's still a Hoover. It's always been a Hoover, right? Growing up.
Yeah, and that's testament to the amazing power of the brand Hoover, but it has got to the point where it's actually diluted their protection a little bit, because everyone's using it for everything, so the actual term becomes less recognizable. But yes, trademarks, they are very, very easy to get. They are relatively cheap to get. They are something you can do on your own, but I would be very cautious doing it on your own because there are various pitfalls that you can enter into. So that is trademarks. Another form of intellectual property that I am demonstrating by virtue of wearing this pin is design rights. And the reason that I'm wearing this Stormtrooper helmet, and hopefully there's no one who knows well enough that this isn't actually a Stormtrooper helmet, it's a Clone Trooper helmet. But anyway, that's by the by. I'm not going to dive into those nerdy depths. But this is meant to represent a Stormtrooper helmet. Now, a Stormtrooper helmet is relevant for design protection because there was a very significant case around Stormtrooper helmets and design rights. And design rights are intended to protect the form, the shape and configuration of something. So it's protecting the design, it protects the aesthetic of a particular product. And in this particular case relating to the Stormtrooper helmet, there was a big debate about whether or not a Stormtrooper helmet was protected by design rights or by another form of intellectual property, which was copyright, because copyright protects aesthetic creations. So copyright protects this broadcast, this recording is protected by copyright because this recording is an aesthetic work. I mean, not necessarily me per se, but the entirety of this production is an aesthetic work. And the outcome of the case is by the by, but suffice it to say that the design studio that created the Stormtrooper helmet won a court case and asserted their rights in the Stormtrooper helmet over Lucasfilm, one of the giants of the entertainment industry. So it is possible for Davids to beat Goliaths when it comes to the IP world. So design rights are another form of intellectual property that are very, very simple to obtain, but can be incredibly impactful to your business. Again, it's another asset. So each of the three forms of intellectual property that I've spoken about so far are patents, trademarks, and design rights. Those three forms are all types of intellectual property that you apply for protection. So those are forms of intellectual property where you've actually got to make a conscious decision to say, I want to obtain this asset, I want to obtain this patent, this trademark, this design. And you go straight to a local patent office. So in our case, the UK Intellectual Property Office, or you go to a patent trademark attorney, or come and talk to me. And you then file various applications for each of these rights. The patent office decides whether or not you should be eligible for those rights. And then ultimately you get granted that particular right. But there are other types of rights. And we've already touched on one of those other types of rights, which is copyright. And those other types of rights are rights you do not have to apply for. They automatically subsist in something that you have created. So again, using this recording, this video as an example, as soon as this has been finished and created, there is copyright, and no one would be allowed to come along and take this video, this conversation, and reproduce it, because they would be breaching copyright. Other forms of copyright subsist in creative works, such as my son's favorite story, which is Monkey Puzzle here. And there are various forms of copyright in that. There's written copyright. There's the artistic copyright in each of the images. And there is a lot that people do on a day-to-day basis in their operations that will create copyright, but they may not realize. And again, it's another form of protection for various things associated with this industry. So photographs, educational videos, standard operating procedures, all of these different things that are written and created will have copyright subsisting within them. We now move on to the slightly less well understood forms of intellectual property. So I wouldn't be surprised if everyone's familiar with patents, trademarks, copyright, and maybe designs. But I have put here some flowers which were dried from my wedding day, and they are not there just for the aesthetic. They are there because there is viable protection for plants, and obviously this is incredibly important for the cannabis industry, with all of the various different types of strains of cannabis plants, of hemp plants, which are all being cultivated to provide varying different levels of THC, CBD, any of the other cannabinoids. And what we have is plant variety rights. Now, plant variety rights are another form of intellectual property, which are, again, relatively simple to obtain, but due to their, I would say, the lack of knowledge of them, it is not something that is used terribly often. So again, it's something to bear in mind that if you are creating unique strains of, excuse me, of cannabis plants, there are options to protect those if they have particularly important properties. And the reason that I'm bringing these up is because it's not possible to obtain a patent on a natural plant, but there are, and people know this, and this leads to a potential preconceived prejudice against obtaining patent protection for products within the cannabis industry, because it's not possible to get patent protection for natural products. But there are other forms of IP that are out there. Another form of IP which is of potential interest within the cannabis sector is represented by this bottle of, well, it's a box, but it contains a bottle of champagne. Now, champagne, again, it's another household name. Everyone knows what champagne is. And the name champagne is very vigorously protected by the Champagne region and producers within the Champagne region of France. And the reason that it is so vigorously protected and why they are able to protect it is because there is such a thing as a geographical indication. And a geographical indication protects the name of a product where that name is linked to a geographical location. So in this case, champagne can only be produced in the Champagne region of France. And there is a very sad story about Camembert, where Camembert, again, wanted, or at least producers of Camembert from the region that it originally came from, wanted to obtain a geographical indication or protection for that geographical indication for Camembert, but they were unable to. The reason being that ultimately it came down to, I think, World War I or World War II, interrupting their opportunity to protect that geographical indication. And then other regions started producing Camembert, and so they couldn't get the protection anymore because it was diluted by other places using the name. So again, I think geographical indications for cannabis plants or other cannabis-derived products could be a really unique way of protecting products for the cannabis industry.
Absolutely.
And I think that brings me, let me just double check. Yeah, that brings me to the end of all of my examples of various types of intellectual property rights that are available to people working within the cannabis space.
Very cool. Excellent. No, really interesting stuff. I think, again, I suppose because, again, just some thoughts from me around the kind of origin stuff. Absolutely. I mean, if you look at kind of like the Emerald Triangle, or kind of like in California, or kind of British Columbia, where they talk about BC bud, those sort of kind of regional kind of, whatever you call them. What was the official term again?
Geographical indications.
Geographical indication. I think that sort of thing obviously plays well into that. And again, I guess for certain strains, but again, would it be that, again, I'm trying to think from the perspective of like a cannabis producer, you couldn't necessarily, or could you, I've got a particular strain, it's called, let's think of one, Ghost Train Haze. Can I copyright that as a kind of strain name? Can I patent? How would something like that work? Would that sort of, because it could be several levels, or again, if you're a CBD producer, full spectrum, or had a specific recipe or formulation, could you protect that? How might those sort of things work?
Yeah, so that dives into a lot more detail. So isolates, let's take that first, because that's patents.
Yeah.
So I have a preference for patents, and it is possible to obtain protection for formulations. So different combinations of entities. If it is simply like, let's say, a press and a different combination, then it is a little bit challenging because it is naturally derived, and just protecting that mixture itself would be difficult. What you need is to demonstrate that that particular mixture has some form of effect. So it comes back to what I was saying at the very beginning, when you need to have some form of technical advantage or technical effect associated with what you want to try and patent. So going back to the pencil, the technical effect was the fact that the compost expanded and spread out and got aeration around the seed. And so if you were to walk up to me and say, I have this isolate, but we've got nothing to demonstrate what it does, then we've not really got much there. But if you walk up to me and say, this isolate is particularly effective at treating anxiety, and we've got data to demonstrate that this particular type of anxiety, or this particular patient class, and it's phenomenal. Other products don't give the reduction in anxiety that we see with this. They're like, brilliant. We'll definitely be able to do something with that. And then when it comes to names, names of particular strains, if it's a new name, there's absolutely no reason why you couldn't obtain a trademark to protect that. And then you create the brand around that trademark. And it's the same thing as, it's exactly the same as Cadbury's putting a product on the shelf and saying, this is the product. And consumers walking up and saying, oh yeah, I like that product, I'll have that. It works exactly the same
with strains, though, because a lot of them are kind of hybrids of two different things. So if you were to kind of use a trademarked kind of strain, cross it with something else, could you still claim the lineage and sort of leverage that, even if you didn't have access to that sort of trademark? I guess that's where
if someone, and this is a benefit for the owner of the trademark, that the owner of the trademark could stop someone from using that mark in their own advertising. So if you've got a really good strain that is gaining a lot of popularity and people are associating that name with that quality, you are generating goodwill in that name, in that brand, in that trademark, goodwill in that product. And that means you can then stop someone else from riding on the coattails by crossing the strains, creating a new one. And what you're suggesting is that someone else then uses the goodwill in that originator strain for the child strain. And that is essentially borrowing the goodwill. And if it was an internal, same company, that's fine, they could do that. But the owner of the trademark for the originator could stop someone else from doing that. And that protects the investment and the work that you've done for that originator strain, so that no one else can come along and start borrowing the goodwill that you've generated.
But you couldn't use the name in the same way through advertising, but you can still use the actual parent strain itself as a product that doesn't require permission from the trademark holder of that parent strain.
Correct, because the trademark protects the name,
right?
It doesn't protect the particular strain. Whereas if you had a plant variety right on the particular strain, then that could stop someone from using your strain in some form of creation of another one, some form of crossing.
No, absolutely. I guess it's easy to kind of think, in markets like America or Canada, where you've got kind of a more of an open sort of, you've got recreational markets, and I know there are restrictions around how you can advertise and which, how do you present things, but essentially you can still create a kind of visible brand. And you can to some extent here in the UK with the kind of medical brands, but I guess this is stuff's going to become more and more important to cannabis industry as, things open up a bit more, as we move towards, and I'm, ever optimistic towards a kind of recreational market and things like that. But again, what are the kind of concerns right now that you're hearing from sort of cannabis producers here in the UK in particular, as they look to kind of scale or kind of create a brand that sort of operates internationally?
I mean, it's not concerns. It's really a lack of conversation almost. So there are a lot of people that I've been seeing doing really exciting things, but I'm not sure that there is the awareness of the various types of intellectual property rights out there. And one of the reasons that I reached out to do this talk was because I wanted to provide the opportunity to bring awareness, especially to some of the plant variety rights and the geographical indications, to bring awareness to those as a possibility for protecting business operations. So when it comes to concerns that I do hear, it is generally the case of intellectual property being very costly. And the cost of enforcing intellectual property rights. And that's one of the reasons why I gave that story about the Stormtrooper helmet,
Yeah.
Because that is an incredibly powerful message that it is possible to take your rights and enforce them against a big player and win.
Yeah.
So and when it comes to cost of intellectual property rights, they can be expensive. Patents can be expensive because there's quite a bit of front-loaded work that goes into them. But trademarks, designs, they are very, very cost effective for what they ultimately can bring to the table. I mean, this is going back some time now, but Kit Kat and various other, I think they're Nestle brands, were valued in the billions a fair few years ago now. The cost for filing a trademark in the UK is a few £100s. Now, that simplifies things a lot because the strategy around protecting Kit Kat will have cost a lot. But the return on the investment there, I think, is clear because the assets that Kit Kat as a brand brings to its owner is incredible. And that is all underpinned off what can be a relatively straightforward intellectual property asset.
But I guess for more sort of burgeoning brands and things like that, or somebody who's got designs on wanting to be a big recreational brand here in the UK, eventually, when do they sort of need to start thinking about these things? Again, there is a kind of indeterminate sort of timeline, but again, it's a case of, is there ever a good time or bad time, or when is the kind of, when does it become apparent that you should start doing this as a brand owner?
Yeah, no, that's a really good question. When to obtain intellectual property is one of the harder questions to answer, because there are a lot of contributing factors to the decision. When it comes to trademarks, you don't have to obtain a trademark before you start trading under a particular brand. So you can dip your toe, see how a brand goes, and then obtain your trademark protection after the fact. The problem becomes if someone else recognizes that your brand is doing particularly well and beats you to the punch, or starts using your brand before you protect it. So the safest way of doing things would be to obtain trademark protection before you start using a particular brand. But that's not always possible. There can be budgetary constraints, so there are a lot of other considerations. But the easiest advice that I can give is obtain intellectual property rights first before doing anything with what's covered with those intellectual property rights.
Very cool.
That's the best rule of thumb.
No, it's it makes sense. It's just, again, this is one of the great things about the cannabis industry. Also, one of the most frustrating, that there is no kind of straightforward way of doing things. But again, I suppose actually, my last question was around the kind of internationality of doing something. If you register something here, does that mean someone in the US could basically take your brand and go, "Oh, that worked here. Let's try it try it across the pond and see if people like it over here"?
Yes. So the territoriality of intellectual property rights is a complication to intellectual property rights. So in order to protect a particular trademark or a patent or a design, you need to have protection in each country where you want that protection. And that is where the cost truly comes from. So if you wanted to protect business operations in the UK, as I say, trademarks in the UK, a couple of £100, relatively inexpensive. If you want to obtain that same trademark in the US, in South America, in Canada, in various other countries, that's when you start getting multiples and a bit more, because you need local advice and local assistance as well, most of the time. Not exactly for trademarks. There is actually an international route for trademarks, which streamlines the process really nicely, actually. But it is multiples.
That's it. There's no, it's fascinating, and I think there's again, there's every opportunity as this industry kind of grows to really start to think about that. And I think that's what more and more companies who are producing and creating their brands are going to start doing. So kind of see. So where can people get in touch with you? Where are you online?
So my firm's name is Hepworth Browne, and we can be easily found in Google. So my name is Stewart Eccles. I can be found very easily on LinkedIn as well. There are not many other Stewart Eccleses. I have a relatively unique name, which helps.
Yeah.
So yeah, if anyone has any questions that might come from this, please do feel free to send me a message, send me an email, grab me on LinkedIn. It is something that I am very happy to give guidance on. And if you don't mind, Dave, I will plug another institution that I am a part of, which is catered to help anyone within an innovative industry. And that is an institute called the Institute of Patentees and Inventors, shortened to IPI. And the aim of that institute is to educate anyone who is innovating or looking to patent particular products. And that's going to be relaunched in early next year. So the goal there is to help anyone avoid pitfalls. And the Stormtrooper helmet is actually one of the examples. And the gentleman involved in this is involved in the IPI also. Very cool. So yeah, so I wanted to just put that out there because that is another source of really useful information for anyone who is looking for help.
Brilliant stuff. No, thank you so much, Stuart. Really appreciate you coming on and telling us all about this. And yeah, look forward to speaking to you soon. So thank you. See you soon.
Thank you. Lovely talking to you. Bye.